Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of AEquitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're doing something new. We're looking at the ways sexual violence, intimate partner violence, stalking, and human trafficking crimes are portrayed in film, TV, and documentaries. Together with my guests, we'll explore how we'd approach these cases if they landed on our desks today, the strategies we'd use, what the law says now, and how we'd support victims in and out of the courtroom to set up the best possible outcomes. Because the law isn't just theory, it's the foundation of real lives, real cases, and real change. Hi, everyone, and welcome back to Just Champions. This week, we are taking on two powerful productions that focus on serial rapists and that each expose the cost of delayed justice and the courage it takes to fight for accountability. And we're going to be looking at Unbelievable, which is a Netflix limited series that is actually based on a true story of a young woman whose rape report was dismissed, only to be proven true years later after her rapist had committed multiple other rapes. And, this is all in the show notes for everyone, but, Unbelievable was on Netflix, but it's based upon the book, A False Report, by T. Christian Miller and Ken Armstrong, which was based on their ProPublica article called An Unbelievable Story of Rape. And I highly recommend people go buy the book and read the article. It's fantastic. And we're also going to be referring to a documentary, also fantastic. It's called I Am Evidence. It was released on HBO in order to learn more about an issue that's going to come up here that we're going to talk about, which is the issue of untested rape kits, and specifically looking at how Detroit, Cuyahoga County, and other jurisdictions went back to, first of all, acknowledge the issue, and then Cuyahoga County and Detroit really were leaders on going back and trying to remedy the issue. And Kim Worthy, who's not with us today, is featured in I Am Evidence, but we're so grateful that Dan Van is here today from Cuyahoga County. Dan Van, I am so happy that you are here. Dan is an assistant prosecuting attorney with the Cuyahoga County Prosecutor's Office in Cleveland, Ohio, where he's been since 2009. And he is the assistant supervising attorney of the appeals unit, where he handles the constitutional and other challenges that arise in criminal cases, to include in cases involving serial rape and cold cases. He argues before the Ohio Supreme Court. He has prepared briefs before the U.S. Supreme Court, and he also works with attorneys in the Sexual Assault Kit Initiative. And rejoining me today is AEquitas Senior Attorney Advisor Patti Powers, who appeared on an earlier episode this season, so I am not going to repeat her credentials here, except I want to remind listeners of Patti's deep expertise in prosecuting serial rapists, cold and current sexual assault cases, and forensic evidence. I mean, she is just she's a wealth of experience. So Dan, Patti, it's wonderful to have you both here.
Thank you for having me.
Patti, we're going to jump right to you. And I know you've been in this position before. When prosecutors are reopening cases after years, maybe even after decades, what are the key considerations that they are thinking of, that you think of in those cases?
The first thing that we do as prosecutors is to carefully review the file. Many cold case files aren't very thick. They're smaller files, but contained within those pages is the victim's experience of the crime. And Jen, it's amazing. I think back to the files that I read, and very, very quickly after getting into it, began connecting with the victim's experience, but also recognizing that with trauma-informed interviewing and many other attributes of a victim-centered prosecution, that there's even more that we can do to give victims a true opportunity to describe their experience of the crime. Once that initial process is completed, We want to carefully account for any extant evidence. Some of that evidence may not have been sent to crime laboratories and may be maintained in police evidentiary storage. Other items of evidence may have not been secured, but may be accessed through other individuals who may have this information. But the first step is to know as much as possible about the victim's experience and then look to evidentiary resources to help bring that experience alive and also to corroborate the disclosure.
And so, Patti, we're going to go right into the case at the heart of Unbelievable. And I know you're very familiar with the book and the articles, but taking listeners back to the report of Marie, it's so interesting. You talk about how some of these files are not very thick, and I would say that is exactly what I would have pictured in that case, because very soon after Marie reported her rape, a rape by a stranger who entered into her home, who used a weapon, who tied her up, who photographed her in an attempt to intimidate her and to prevent her from reporting. So, Patti, in thinking about Marie's case, which was so soon after her report, the investigators in that case turned from conducting any kind of an investigation, really, other than looking like they were attempting to collect evidence from the apartment and questioning her multiple times. Very soon after, turned from searching for evidence to accusing her of creating a false report. So this idea of this thin file, it exactly encapsulates what I imagine the file looked like in Marie's case. And so as that prosecutor, assuming you have a case like that where a victim has had that experience with law enforcement, what are your considerations and how are you going to be approaching Marie?
That's a great question, Jen. And I want to tell you that as I was reading the story of Marie, it really came alive, Marie's experience of the crime. It was palpable. It was eloquently expressed in her disclosure. One of the things that was most concerning about the beginning of the case were how people that were close to her began questioning what she told them about the crime, people that she trusted. And from that point on, there was an effort by others, including law enforcement, to focus on inconsistencies. And as a prosecutor, we know that inconsistencies can be a function of trauma. They can also be a function of who is asking the question, what a victim is able to share during the time that that question is asked. There are so many considerations. But in Marie's case, there was an immediate focus on inconsistencies and the potential that perhaps this may not have happened to her. And then law enforcement began asking her to actually become involved in a recantation if it was not true. And so at that point, there was a disengagement on Marie's part. And I think some of the reason was she wasn't supported. And we know now how important support from law enforcement professionals as well as individuals who are close to victims is.
It's interesting. And again, drawing from art in this case, because the series Unbelievable was, like I said, was based on the book. It doesn't chronicle it. Some of the names are changed directly, but there were some examples of other victims who, like Marie, had maybe lost some trust in the system. As the prosecutor who's coming and meeting Marie or other victims like that for the first time, how do you regain that trust?
It's so important for prosecutors to be themselves, to be authentic, and to realize what a victim has had to undergo and able to step forward to make a disclosure. As we all know, most victims do not take that step to disclose crimes, particularly victims of known offenders, because of distrust in the system, because of a fear that they may not be believed, because there might have been a relationship or an acquaintance. And so with all of that in mind, when a victim walks into the office of a prosecutor, there really should be a feeling of deep respect for the courage of the victim and being able to step forward. And in return for that, we want to honor the victim's trust that they have reposed in us. And I think to do that, Jen, the best way is to be ourselves, to be authentic, and to share with the victim the privilege that we have as prosecutors to be able to advance their case to justice.
Is there an opportunity when you're in a case like this to address directly how the victim has been not responded to appropriately, even mistreated in some cases? I mean, it's very delicate, I can imagine. But have you had that experience? And what have you said? How have you engaged with the victim at that point?
Well, I think the first step is to listen carefully to the victim about the history of the process that they've been involved with. And if you really listen on a deeper level, you begin hearing sometimes anger, certainly dissatisfaction, and palpable fear that perhaps they weren't believed. And perhaps that's why there was not better support from law enforcement, for example. And so when we become acquainted with those feelings, what's so important is to answer questions directly. If there's been, for example, a lapse in an investigation, we're in a position to explain the reasons for that lapse and to apologize if there should have been work undertaken that was not.
And you kind of talked about this before with respect to repercussions on evidence. And and these can be in cold cases as well, when maybe police have followed every lead, but the leads end up, that's why they're called cold. Sometimes they're not able to come to a conclusion and come to the identification of a suspect at that time. When a case is an older case, that new evidence has been revealed and we're able to reopen it, or if a case was backlogged, what are some of the evidentiary challenges that a prosecutor has to face in those cases, and how do you overcome them?
The first thing that we want to do is to account for all of the evidence, and we're going to look to older evidence logs. Now, in some cases, over a period of time, law enforcement may have gone to a new building. Evidence that was previously held in one building may have been taken to a completely different place. So initially, we want to make sure that we're tracking the evidence. Then we're going to look at evidence that was submitted to crime laboratories and look for those crime laboratory reports to see what work was done and what the capacity of the crime laboratory was at that point. With regard to a finding of mixtures, and there are many findings in many sexual assault cases of a mixture, in earlier times, there may not have been the capacity to isolate a specific donor profile. That can now be done, and so there certainly would be an opportunity to submit that evidence for retesting. At that point, there may be a request from a crime laboratory to consume evidence, meaning to use up all of the residual DNA. And that's an important consideration as well. We want to try to reserve DNA for future testing if a person is charged, for example, and defense counsel wants to be able to review that evidence. So there are a lot of conversations that are going to take place between prosecutors and law enforcement, as well as with the crime laboratory.
Hey everyone, Jennifer here. I want to pop in because we've used some terms that are specific to DNA analysis that I want to just define briefly. First, about mixtures. DNA technology is always advancing. And in the last decade or so, it's incredible. Forensic experts have been using new techniques to analyze DNA mixtures. And mixtures occur when the evidence contains DNA from several people, obviously. The second is YSTR testing. And STR refers to short tandem repeat markers found on the Y chromosome. And those enable male-specific DNA testing. And they're useful in cases involving sexual assault because, variations in YSTRs can be used for distinguishing individuals and in biological relationship and ancestry testing. Okay, let's go back to our discussion.
I should also mention that sometimes there is evidence that was never sent to the crime laboratory because there was not an understanding that DNA could have been found. And we know now that there's a possibility. But it all begins with looking at the evidence log, finding the evidence, securing it, seeing what has happened, and then consulting with forensic analysts to see what else we can do regarding the testing of the evidence.
And in addition to, all the important forensic evidence you've just talked about, and then going back to the DNA and thinking about how it helps us identify, an unknown suspect, of course, but also helps connect if when we have a known offender, may connect them to previous crimes, may confirm the identity of a known offender. And, we forget it. Another important piece of DNA is to exonerate innocent suspects, if that's the case. But when we're going through and considering all of this evidence, I'm wondering if you can talk to us a little bit, and I know it's a very big subject, but a little bit about how testing of DNA has evolved over the last, over the decades, if you will, and, how that's impacted our ability to prosecute these cases.
The testing that's available now, we're basically able to achieve testing and achieve results with an even smaller quantity of DNA. So that's very important. STR testing is essentially the gold standard for current testing. If there is a mixture, a finding of mixture, or if there is a male on male sexual assault, then there's an opportunity to conduct YSTR testing. Now, that doesn't have the same kind of statistical reference that the other kind of DNA testing has, but taken together with other evidence of the crime, it still is very important and helps support, again, that aspect of the case with identification. And, even if an offender is known to the victim, and certainly the great majority of cases that we've seen are with known offenders, it still is an important aspect of the work of investigators and prosecutors to establish identity. Without the opportunity of establishing identity, we would be looking at perhaps the denial defense instead of the consent defense, which is traditionally used. So doing all of that work is critical. And that's one of the things that we learned from testing of untested sexual assault kits is that the evidence can also lead us, once it's uploaded into the CODIS system, it can also lead us to other victims as well as associate with other crime scenes. So the testing of forensic evidence and certainly how it's developed has really opened the door to that particular evidentiary resource and is also helping us to acquaint ourselves with the incidence of serial or repeat offenders, which we know now are significantly there.
Thanks so much, Patti. And I think at this point, I know we're talking about unbelievable, but I'm going to take it now down this issue of the serial rapists and, interestingly, the, unbelievable is and the victims and how they're treated. I feel like these untested rape kits are the evidence of sort of the bigger issue with how rape cases are approached. And Daniel, I know that you have a lot of appellate expertise, and I certainly want to get into the details of the appellate issues around cases like this. But first, I think I want to just bring us into the real life implications of sort of the scenarios that played out in Unbelievable, because you were in one of the first jurisdictions in this country to really deal head on with the massive quantities of untested rape kits. And I wonder if you can talk a little bit about that experience in Cuyahoga County and what you've learned, what you all learned from that.
Sure. And again, it's been a real privilege for me and an honor to be able to work with the trial prosecutors, the investigators, the victim advocates, all of those who were involved in the sexual assault kit initiative out of Cuyahoga County, Ohio. And I think, our experience, we've certainly learned a lot about the importance of testing sexual assault kits, all sexual assault kits, not just sexual assault kits that come from stranger rapes, but also acquaintance sexual assaults. A lot of this has been reported before through Rachel Lavelle's work in collaboration with our sexual assault kit initiative. But I think what we've learned, and the most recent numbers I have on this issue, we've our initiative certainly has resulted. We've had thousands of indictments. Still, unfortunately, we've indicted over 100 John Doe cases, but we have identified hundreds of serial rapists. So we found that we have over 600 serial rapists kit to kit. And these are individuals who may not have had a prior conviction. So you certainly see the viability of testing an alleged acquaintance rapist, because that person's profile may not be in the CODIS database at all. So that certainly gives investigators a lead to investigate these sexual assault kits.
One of the things I really think about with your work in Ohio, and you talk about Rachel Lavelle, and I think the close working relationship that had, and I remember visiting I think it was in 2015 with everyone around a table, and just this close working relationship really produced an understanding that went far beyond Cuyahoga County. I mean, it was things that other research had indicated was likely true, but we started to have some more quantitative research about how our rapists behave. You just alluded to it in your response. We see this in Unbelievable. And in the documentary we referenced at the beginning, I Am Evidence, with the fact that our rapists don't follow a specific pattern, identical victims, identical age of victims, identical race, identical crimes, and even necessarily always escalating their crimes. Our perpetrators, our rapists, we know they commit other crimes, sometimes non-sexual assault related crimes. They go after victims of all ages. They use weapons, and then they may not use a weapon. One of our attorney advisors calls this leveling up. And I think even in Unbelievable, there was that statement made that the more you do something, the better you become at it. Can you talk a little bit more, Dan, about what, this phenomenon of our perpetrators maybe not following a script, but really acting in ways that may seem disparate, but actually they're helping them hone their rape craft better?
I think for me, probably the best example I can draw upon was working with prosecutor Mary Weston in the Nathan Ford trial. So Nathan Ford was became a notorious serial rapist in Cleveland. He had been previously convicted, pled guilty, convicted in 2005 of multiple sexual assaults. His DNA profile was in the CODIS database, and through the work of the Sexual Assault Kit Initiative, his profile linked to many more DNA profiles. So that resulted in 2 subsequent indictments. And I think what we saw is this exact reflects the exact phenomenon. There wasn't any singular type of victim as far as who he was offending against. His victims came from all walks of life. They were different ages, different ethnicities, but there were certain similarities in how he carried out the sexual assaults. For example, and it seems that, for example, when he perpetrated the sexual assaults, he would order his victims to lay down on either their clothing, and these were when he was sexually assaulting women in the streets. Later, when he progressed to home invasions, he had asked his victims, I believe it was a towel. I think another feature that stood out is how he instructed his victims to count to a certain amount of time before he would flee. So, certainly when we talk about modus operandi, so to speak, or this behavioral fingerprint, no, he didn't have a certain behavioral fingerprint when it came to the type of victim, but the manner in which he carried the sexual assault certainly was very similar. And I think that leads into other discussions topics we can have about other acts evidence and joinder of cases.
As you know, probably the most appealed issue across all criminal cases, I think, but particularly in sexual assault too, are motions to admit a perpetrator's other acts evidence. It's the federal rule is 404B. So we are seeking to introduce other crimes, or it doesn't even have to be a charged crime, other acts of a perpetrator, not to demonstrate, not for propensity, not to say this is a bad person before, so now they committed a rape here, but for a specific purpose. And these are, enumerated out. It could be intent, lack of mistake, motive. MO is one of them. But I'm wondering, in these cases, when you're faced with these appeals, which I know you are frequently, what is your approach? What are the type of arguments you are prepared to counter in these appeals? And how do you overcome the defense trying to reverse a conviction by saying, these other acts were inappropriately admitted at trial?
I think, first of all, where it starts is at the trial court level, because of course, anyone ready to prosecute a case, would file some sort of notice or motion alerting the court that of an intent to introduce other acts or 404B type evidence. In Ohio, we have evidence rule 404B, which fairly mirrors the federal rule. What I think we've learned just through more recent litigation is the real importance for prosecutors to be very deliberate in their use of 404B evidence. Like you said, different evidentiary rules have an enumerated list of proper usage of other acts evidence. It's not for propensity. It could be to show opportunity or absence of mistake. And I think where we've had some negative case law is where we've had prosecutions where we've argued the laundry lists of reasons. We've put everything out there, and we've instructed juries of all of the different non-propensity purposes. But I think we need to be more specific. And I think the other challenge, and this is based on, the case law and experience with oral arguments, questions from jurists, is convincing the court that when it comes to, let's say, modus operandi, a lot of the case law we have in Ohio right now talks about modus operandi being this behavioral fingerprint. We need it to be able to identify the perpetrator. And I think the reaction is that, well, if you have a DNA profile, then why do you need this other acts evidence to prove this behavioral fingerprint? You have the DNA profile. So I think part of it is also convincing the court that, we have a valid reason to introduce this MO type evidence, even though we have the profile.
And no, that's such a good point. And Patti, I'm wondering, what do you think about that? We know that the court has, when I say the court, decisions, I mean, we're lawyers, we live in worlds of precedent, but we also know that there's issues of first impression, or there's areas where the research starts to reveal inaccuracies in the way we've looked at things before. And I think, as Dan points out, there's such a premium put on MO, that there's this behavioral fingerprint, rather than understanding how perpetrators, like anyone else, learn from doing the same thing with different strategies to figure out how they can identify and isolate their victim, perpetrate their crime, and get away with it. So how do you meet those challenges? Like, as the trial prosecutor, how are you making the arguments, not only that the court understands, but that then Dan has a solid record and a way of defending this up at an appellate level once you get your guilty conviction?
I think pretrial is very important in these cases, and especially making the record with the specific basis or bases for admission of the 404B evidence. And I want to put this in the context of what we're currently learning. We've all referenced Dr. Rachel Lavelle, and one of the things that we know from research done within the Sexual Assault Kit Initiative is that there can actually be intraserial variation, even involving genders. Now, when we look at case law around the country, so much of the case law is still primarily focused on signature crimes, on a very definite modus operandi. There may not be a signature crime. There may be more subtlety involved in the commission of that crime. One area that I think we could really explore is the use of alcohol in known offender cases. This may be give us a basis for seeing what that continuum of the offense is, how alcohol is used. So in that regard, I think making the record at pretrial is critical. And, I think that we should look at offering expert testimony as well to talk about the changes in offender patterns and how there might be subtleties that the court may not be familiar with.
And, talking about these other crimes, it has me thinking, I think this also brings in the, fact versus fiction. I think if people watched Unbelievable, what they might have been surprised by or maybe thought was dramatic license was the stalking component that this perpetrator was involved in to, again, find the opportunities to rape his victims, sometimes even committing burglaries and taking things before he actually went in and committed the rape. And I'm wondering if that tracks for you. I mean, I guess I've sort of spoiled it because, in fact, it is something that we see that's common. But I want to ask you to talk a little bit about this intersection between stalking and sexual violence.
Well, stalking is a component of many, probably the majority of sexual assault cases. It's how an offender gains intelligence about a victim, about their associations with other individuals, their personal habits, what time they may go to bed, whether or not they are used to leaving a window open to have fresh air. There's so many aspects of a victim's life that an offender wants to gain intelligence about as they plan that crime. And that really takes us to a significant point, I think, how rape is a crime of premeditation. Now, we don't have a jurisdiction that requires us to prove intent or premeditation beyond a reasonable doubt, but this certainly would be helpful to a jury to know the level of planning that goes into the sexual assault and how an offender uses stalking to gain intelligence. And essentially, a victim is unaware of the approach of the offender. The victim doesn't see it coming and is not able to take any steps to protect themselves.
So, Patti, are you going to want to charge that stalking in your case in chief?
Definitely. Stalking should be charged as a crime when we have that kind of evidence. And it's something, again, that helps the jury to understand offender conduct and offender behavior. Rape is not a crime that an offender commits without advanced thought, without considering the intelligence that they're able to gain about a victim's habits, for example. So I think that really helps us in charging stalking to address the totality of an offender's conduct.
And I'm assuming it would be really important for you in your case if if law enforcement in your case had uncovered or as part of their investigation, if they had looked for evidence of stalking, and even in other cases, other, again, stalking crimes, if you're thinking about your perpetrator as you have them, would it have been important for you to know if that perpetrator had been reported for stalking before someone else, even if that crime didn't end up in a completed rape?
I think that's very important as well. And I can think of cold cases where witnesses from neighborhoods were still able to testify about the appearance of an offender's vehicle, and sometimes even an offender's conduct getting outside of the vehicle. So it's important, both in current cases as well as cold cases, to really support an investigation that's going to reach out to the predecessor crime or the predecessor conduct. I think it's really important to give the jury the full picture of the offender and how they have planned that crime.
Yes, such an important point. The training of law enforcement and prosecutors to make sure all the evidence is gathered is so important. So, Dan, I guess that's what I want to come to you about when from your perspective, again, in the appeal, if you have a case where the rapist, the defendant has been charged with stalking, in addition to the related rape case or something else. Does that change? Strategically, how does that change your argument and the legal arguments available to you on appeal and your legal arguments to the court as it relates to maybe other acts or other things that the defendant has done?
Sure. I think it's very important for how I would approach it on appeal and how any court would address it on appeal, because, if you charge the offense of stalking, then it's no longer an uncharged other act. It becomes part of the charging document, becomes part of the indictment. So now you are asking the jury or the fact finder, as a trial prosecutor, do you believe beyond a reasonable doubt that the defendant is guilty of these two offenses? So that is, very much a fundamentally different question than, let's say, prosecuting the rape or the sexual assault and trying to convince your trial judge that I need to offer this uncharged incident of stalking as proof of, let's say, opportunity. So yes, I do think it's very important to consider charging those other crimes that paints the full picture, so to speak.
Yeah, I mean, I think you're right. It's so critical because it not only captures accurately what the victim suffered through this, so it's respectful of the victim. It furthers justice because it captures the whole criminality of the perpetrator. And strategically, it helps the prosecution because it strengthens our position, both in helping to really expose the perpetrator for who they are and how they committed their crime, and so achieve our burden of beyond a reasonable doubt, and then ensure we have this record set up on appeal, so that it strengthens everything. Sometimes Hollywood over-dramatizes. I'm not going to say everything was captured well or perfectly, but I think it did a good job of explaining to the public some of the tools available. It even talked about VICAP, talked about CODIS. I mean, we could go on and on. But I guess the way I would like to end it with the both of you is to just talk about in these cases with serial rapists or cold cases, if each of you, and I'm going to start with Dan, if you could talk about what improvements we have made as prosecutors in these cases, and maybe what some more opportunities for us to do better look like.
Sure. And I think I did want to mention another piece of it, if I may, real quick.
Sure.
So, earlier I gave the number that through our initiative, we've identified 600 kit-to-kit serial rapists. And again, when we expanded that number to also consider prior convictions, we've identified 900 serial rapists. So I think there's a lot going in play here is partially when it comes to stranger sexual assaults, understanding the body of research, understanding the logic, understanding why it can be important to test every sexual assault kit, in Ohio, every sexual assault kit is now tested under legislation that came about because of the backlog. And I think, it's also important, what Patti had mentioned, to listen to our victims, for prosecutors to work together with their investigators, with victim advocates, to really, do our best to bring justice for victims.
No, and I'm glad you actually circle back to that because, and again, it's we'll put this all on the show notes, but people should realize some of these perpetrators, I mean, there were perpetrators in Detroit who were tied to 40 different states. I mean, what we do in our own jurisdictions makes a difference across the country to victims who will never meet. And, every day, I would say every year, we're even doing better at collaborating with our partners nationally to make sure that we are sharing information so that when these rapists, if we miss them in one jurisdiction, we're grabbing them in the other one. So I'm really glad that you brought that up, Dan. And Patti, I guess if I could just ask you that in terms of, your thoughts on how we have or can continue to strengthen our systems to ensure that these kits are tested, that all of these cases and files are reviewed thoroughly, that survivors are treated with dignity right from the beginning in these cases.
We've made great progress. We've learned much along the way. We've learned from the depth of research being done in the Sexual Assault Kit Initiative. We know that there is a significant incidence of serial offenders in both categories of offenders who are known to the victim and also categories where they are unknown. That's very important, but we've also learned that there's crossover offending, how an offender may commit a sexual assault against a victim who is in a relationship with the offender and may have previously or in the future go on to offend a victim they do not know. And what this really speaks to, Jen, is the inherent danger in sexual assault to both victims as well as to the communities. This is what we've learned, but there's so much more that we can do. And I think you mentioned earlier how important collaboration is. Prosecutors need to be speaking with their investigators about what we're learning about, for example, all of the progress made in forensic science, how we're able to determine even more evidence from crime scenes that can be useful in that prosecution. It's also important that we continue our support of victims to really bring to fruition a culture and an atmosphere where victims are free to describe their experience of the crime, where offenders cannot commit these crimes of violence with impunity. And it takes all of us in this process to advance justice.
No, Patti, that was so well said. I mean, what you and Dan have said, the productions that we were dealing with today, both Unbelievable and I Am Evidence, remind us that accountability doesn't end when a verdict is read. It starts with every decision made along the way. So I really want to thank both of you for spending a significant amount of time with us today, kind of with me, not only demonstrating the commitment that you bring every day to this work, but really sharing your analysis so that justice is possible for survivors everywhere. And Patti, we've already asked you these questions. So I'm going to, and so people should, if you haven't listened yet to the episode with Patti, can hear her responses. But Dan, we have some rapid fire questions that we like to end with.
Okay.
So the first question I'm going to ask you, Dan, is if a movie were made about your work as a prosecutor, what detail would you insist they got right?
I think that they would have to get right truly the experience of arguing a case in front of a panel of judges, right? And I think that might be a little difficult because we've all seen the trial movies. We're all, every movie out there that has to deal with a trial setting, realistic or not, My Cousin Vinny, Few Good Men. Not too many movies about, an actual oral argument in front of the Ohio Supreme Court or, the U.S. Supreme Court.
No, I love that. Fantastic. And a very, very important part of the case because it helps solidify all the work that's done at the trial level. And as a former trial attorney, I will say once again, thank you to my appellate colleague for all of your amazing work, both after the fact and to prepare us so that we're trying our cases better. Okay, second question. What do you think, and you sort of alluded to it, what's one thing that Hollywood never shows about these cases that you wish people understood?
I think it's the, all the preparation work that goes into either working on a trial or working on an appeal. Hollywood doesn't show the prosecutor securing subpoenas, convincing witnesses to come to court, doing the legal research, writing the briefs, writing the motions, writing the appeals. We don't get that from Hollywood.
Right, the boring. I think in sports they say it's the boring work, right? But it's the important work. It's all the work that prepares you that leads to the success. And then my last question to you is, why does this work matter to you personally?
I think in my particular line of work, I think why it's important to me is, and again, I earlier kind of said I was a background player, and I say that because, day to day, I typically don't have the encounters that the trial team, the victim advocates have. Certainly after the fact, especially now, we do have conversations with victims trying to tell them what is going on in an appeal. But I think, when it comes to appellate work, you're trying to create a good body of case law. And when we're trying to create a good body of case law, it's not just about the one singular case. It's not about the case immediately in front of you. It's about what that decision in that case means for future cases. So you can certainly see how a negative or not so favorable interpretation of the other act's evidence rule for prosecutors might affect future prosecutions. So obviously, I think for me, it's part of being part of the team, being part of helping to secure justice for victims.
Thank you, Dan. That's such a brilliant way to end this. Thank you, Patti, both of you for this insightful discussion and both of you for sharing your expertise and your dedication to this work. I appreciated it.
Thank you, Jen.
Thank you.
And for everyone else listening, be sure to follow and subscribe so you don't miss next week's episode. We're going to be breaking down You. That's the Netflix series that addresses stalking. And we'll be doing it in a way to really understand how these perpetrators operate and how we as investigators and prosecutors can keep victims safe and access to justice. Thank you. This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about AEquitas, please go to AEquitasresource.org. That's AEQUITAS resource.org, or follow us at AEquitas_resource on Instagram. This series is executive produced by Jennifer Long, AEquitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.